Good morning, this is your Kelso Report for Friday, March 8th, and I'm your host, Clark Kelso. We begin today with a standing decision by the Ninth Circuit in the context of a pre-enforcement challenge to the constitutionality of an election law statute. Then we turn to the application of the Rooker-Feldman doctrine, where a federal action seeks damages for the allegedly illegal enforcement of a misdemeanor ordinance. Next, the California Supreme Court faces the question of whether the trial court should have given an escape rule instruction in the context of a felony murder conviction. And finally, we get a reminder in the Public Records Act cases that appellate review is had exclusively by way of writ of mandate. Now, as I'm sure you all remember, federal courts have Article III's jurisdiction only over claims that present a case or controversy. And to meet the case or controversy requirement, plaintiffs must establish that they have suffered an injury in fact. Standing was the issue before the Ninth Circuit in Libertarian Party of Los Angeles v. Bowen, where the plaintiffs were circulators for political candidates who wanted to secure signatures on nomination forms. Well, under California law, a circulator has to be a resident of the same district in which the candidate is running for office. But the plaintiffs wanted to have circulators who were not residents of the same district. Well, before violating the law and suffering an enforcement action at the hands of the Secretary of State, the plaintiffs filed suit in federal court seeking a declaration that the residency requirement as applied to circulators was unconstitutional. In order to establish standing in a pre-enforcement context like this, plaintiff must demonstrate a realistic danger of sustaining a direct injury as a result of the statute's operation or enforcement. The district court dismissed the complaint on the ground that plaintiffs lacked standing, but the Ninth Circuit reversed, finding that the plaintiffs had articulated a concrete plan to violate the law in question, that the Secretary of State's office had communicated a specific warning that it would initiate proceedings, and the Secretary of State had in fact previously enforced the statute against others. That was enough certainty to meet the case or controversy requirement according to the Ninth Circuit. Next we have a case involving the so-called Rooker-Feldman doctrine. Now, when you lose in a state trial court, your only recourse, as a general matter, is to file an appeal to a state appellate court. If you try to file an action in a federal court that, as a practical matter, challenges the legality of the state court judgment, the federal court will dismiss the action for lack of jurisdiction under the so-called Rooker-Feldman doctrine. In short, you can't seek to reverse a state court judgment by filing an action in federal court. The applicability of Rooker-Feldman was before the Ninth Circuit in Bell v. City of Boise, where a number of homeless people had been cited and convicted of violating two local ordinances that made it a crime to camp on the streets, sidewalks, parks, or public places. The homeless ultimately filed an action in federal court under Section 1983, alleging that the city and city law enforcement personnel had enforced the ordinances in violation of the Eighth Amendment. They sought both prospective relief and injunction and a retrospective damages for the prior convictions. The district court dismissed under the Rooker-Feldman doctrine, reasoning that the federal complaint's request for retrospective damages essentially sought to appeal and reverse the state court citations and convictions. Interestingly, the Ninth Circuit reversed. The court explained that, although the plaintiffs sought to recover damages suffered from the state court judgments, they did not allege that the state court committed legal error, nor did they seek relief from the state court judgment itself. Rather, the plaintiffs sought only to recover damages for an allegedly illegal act by an adverse party, the city, for its unconstitutional enforcement of the ordinances. According to the Ninth Circuit, so long as the plaintiffs did not make a direct challenge to the state court's factual or legal conclusions, Rooker-Feldman does not apply. Well, I have to say that I think the panel's reasoning is not all that convincing. Sounds to me like a distinction without a difference here. Damages are not going to be appropriate unless the federal court concludes that the Eighth Amendment was violated by the city. And if that is true, there never should have been state court convictions. I just don't see how you can award damages here without essentially concluding that the state trial court entered an unconstitutional judgment. Well, we'll see if the Supreme Court takes notice of the Ninth Circuit's decision, or whether it will stand as is. Next, we turn to the felony murder rule, a wonderfully complex area of law. The felony murder rule generally provides that if a killing occurs during the defendant's commission or attempted commission of certain statutorily listed felonies, the defendant may be convicted of murder without examining the defendant's particular intent to kill. In essence, the mental state for felony murder is simply the intent to commit the underlying felony. Now, one of the issues that frequently arises in a felony murder context is whether the killing occurred during the commission of the felony or whether the killing occurred long after the felony had been concluded, so the felony murder rule does not apply. That issue arose in People v. Wilkins, where the Supreme Court of California examined an appeal of a first-degree murder conviction under a felony murder theory that the victim was killed during the commission of a burglary. The evidence was that the defendant burglarized a house under construction and loaded some large household appliances onto the back of a pickup truck. An hour later, and 65 miles away, as he was driving on a freeway, an unsecured stove stolen in the burglary fell off his truck. Another driver swerved to avoid the stove, crashed into a large truck, and was killed. The trial court instructed the jury that for felony murder to apply, the burglary and the act causing the death must be part of one continuous transaction. But it refused the defense request to give a so-called escape rule instruction to the effect that the felony continues only until the perpetrator has reached a place of temporary safety. In other words, has escaped. Well, that place of temporary safety breaks the causal chain between the felony and the killing. The Supreme Court held that the trial court erred in refusing to give the escape rule instruction, noting that there needs to be both a causal nexus between the felony and the killing and a temporal relationship between the felony and the death. On the facts in this case, a jury could have found that too much time had passed and too great a distance existed between the felony and the killing. And so the escape rule instruction should have been given to the jury. Finally today, a question of appellate jurisdiction. The plaintiff in Mincal Consumer Law Group versus Carlsbad requested production of certain records held by the Carlsbad Police Department. The department gave the plaintiff an opportunity to inspect a media log, but otherwise denied access to records more than 30 days old on the ground that they were considered historical records. History happens quickly in Carlsbad. The plaintiff unsuccessfully filed a petition for a writ of mandate under the Public Records Act, and then filed a notice of appeal from the Superior Court's judgment denying the petition. Well, unfortunately for the plaintiff, the Public Records Act expressly provides that a petition for a writ of mandate filed with the Court of Appeal within 20 days of the trial court order is the sole and exclusive basis for seeking review of a trial court's decision under the Public Records Act. The purpose of this provision is to expedite appellate review of Public Records Act cases by requiring the parties to use the generally quicker writ of mandate process for securing judicial review instead of the more leisurely review occasioned by invocation of appellate jurisdiction. Now, this rule obviously can be a trap for the unwary or inexperienced practitioner who, unaware of this special provision, tries to file a normal appeal, which is what you do in pretty much every other case. Well, if you make this mistake, you will find your appeal dismissed for lack of jurisdiction. And you can be sure that the time for filing the writ of mandate has long since passed. It's one big oops to explain to your client. And that's it for today's Kelso Report. Have a great day in the law.